Hi, everyone. Thanks for joining our live webinar today. I can see we're about 30 seconds early, but I thought I'd just start the broadcast because I can see there's quite a few of you on already. So thank you for joining and thanks for being keen and joining early. That's fantastic. We have a chat box to I think your right of the screen. So if you've got any questions or comments, just put them there in the chat box. And in fact, it's probably a good time now. If you're happy to share who you are and where you're from, that will be good for other attendees to see, because I suspect there's quite a few service providers and people might know each other and so on, and it's always nice to do that. The other thing, if you're having any technical issues, just pop that in the chat box as well. And we have Elham, our firm manager, is co-hosting this webinar today. And Elham will... Hi, Lorraine, thanks for your comment from Ipswich. Wow. Elham will respond there to any questions or difficulties that you're having. And she's our firm manager, so she's very good with IT. The other thing is we've got some polls. If you scroll down a little bit, you'll see some polls there. Answer those while you're waiting for us to get started, which we will do in about 20 seconds. There's a few more people joining us now. Oh, hi, Matt. How are you? Thank you for joining us. That's great. I think you're from the advice. Oh, Kerry from Mount Gambier. Gee, we've got a good spread of... Esther from Flinders. Hi, Esther. Thanks for joining. Cool. We've got a couple of people here who are going through separation themselves. Okay, so what I've done, just in terms of an intro, what I've done is I've kind of prepared this webinar to be helpful for anyone who is going through separation themselves and perhaps is in the unfortunate position of being in court, but also for service providers supporting those clients. I've also geared it a little bit to the side of students such as Matt, and we've got Esther there as well, and lawyers. So I've made reference to case law and so on, and to sections of the Family Law Act and other legislation that's relevant. I'm not going to go too deep into it. I might in parts. I am a lawyer. But I've made the reference there. There's a number of articles and so on. And what I'll do at the end is I'm happy to provide that and have a chat to anyone offline as well, if you want to have a bit more of a detailed legal chat. But certainly you'll find reference there to the relevant legislation. So I hope that really helps everybody. I think particularly people going through separation in family law courts, I really hope it's helpful for you, but I also am mindful that I want everyone to take something away from it. And we've got a kinship carer just joined us as well. Got another lawyer from EMT Legal. Hi, Tegan, thanks for joining us. All right, so the pressure's on. I've got a lecturer, I've got a couple of lawyers. All right, those that have just joined, we've got the polls below as well. Just answer those polls and give us an idea of who you are. So let me move on to my next slide. Who am I? For those of you that don't know, I've got my website there for my law firm. I'm the principal solicitor of the Family Law Project. We've been in business for about 7 years now, and I've been practicing as a family lawyer myself for 17 years, long time, and I've been doing independent children's lawyer, ICL work, for 12 years. Oh, hi, Virginia, Aboriginal Legal Rights Movement. And that's a beautiful lead in, Virginia, because I was just about to say, I started my independent children's lawyer career when I was outposted to Aboriginal legal rights in South Australia. So at that time, 12 years ago, I was appointed by the court to act for Aboriginal children. So that's where my ICL career started. I then went off to New South Wales and did lots of ICL work in Sydney and surrounds, Wollongong, Dubbo, etc. And then I opened up my own business. So I'm a small business owner. I'm a private practitioner. I'm not employed by any legal aid. I'm not employed by government, but I'm now doing ICL work in my capacity as a private practitioner. Okay. So I've got a little caveat because I am a lawyer. Lawyers love caveats. The caveat at the outset is, look, I really hope you find this helpful, but it's not specific legal advice, okay? So if you are going through your own family law matter, get some specific advice that's relevant to your particular matter, because every particular matter does differ. And I'm also going to apologise at the outset. It's really bad timing, but just as of last night, I've got a really incredibly sore throat. So I'm going to be sipping away at tea throughout this webinar, and I apologise in advance for appearing rude. Okay, those that have joined, any new ones, just let us know where you're from. That's really helpful. So what we're going to cover in this lecture, we're going to talk about what the definition of an ICL is, when the ICL is appointed, who can apply for the ICL, what our roles and our duties are as independent children's lawyer. We're going to talk a little bit, or quite a bit, about the child's views and the child's wishes, because that's always a hot topic and something that people always have questions about. We'll talk about the practicalities in terms of how an ICL is appointed and who pays for them. And if we've got enough time, we'll talk about how to get rid of us, the removal of an ICL. I'll just continue to watch the clock. If we don't have enough time for that, then I'm happy to talk offline to anyone who's interested, particularly interested in that topic. So taking a step back, so when we're looking at independent children's lawyers, in the context that I'm talking about is in the Family Law Courts of Australia. So we're talking the Family Court of Australia, Family Court of Western Australia, which is where I am today. I'm in Perth today. And we're also talking about the Federal Circuit Court. So we're talking about all family law matters. And I've got some old stats there from National Legal Aid back in 2016. They were the most recent stats that I could obtain. But just so you've got a bit of context, in the year 2015 to 16, there was 4,800 ICLs appointed by the court in that period. So it's not insignificant. It is significant, okay? So it's a large number of independent children's lawyers who are appointed. So when we're talking about what is an ICL, sorry, I just went to change my slide there. Because I want you to be able to see more of that and less of me. Okay, so an independent children's lawyer is defined under the Family Law Act 1975, and it means a lawyer who represents the child's interests in the family law proceedings under the appointment of a court. So the critical point there is that we represent the child's interests as opposed to acting on the child's direct instructions. And we act when there's an order that has been made by the court. So we're specialist family lawyers. So before doing the children's lawyer training, we need to have done at least 5 years work as a specialist family lawyer before that point. Once we've got at least 5 years specialist family law, we can then do the ICL training. If we pass that, and if you don't pass that, then you probably shouldn't be doing the ICL work. But once you pass that, you then apply to be on a panel in a particular state. So your legal aid panel of your particular state, and each state in Australia has different legal aid panels. Which takes me beautifully to the next slide. So if we're looking at independent children's lawyers state by state, what you're looking at there in that chart, and you can see each state has been quantified. And again, these are AIFS stats from 2012, the most recent I could get, believe it or not, because we're now 2020. But we're looking at, when we're talking in-house ICLs, they're lawyers that are employed by legal aid. So like I was saying before, when I used to be employed by legal aid in South Australia, I would fall under that in-house ICL category. And likewise with New South Wales, you can see there's lots of ICLs at that time, 70, so I was one of them. And at the moment, because I'm a private panel, for example, I'd fall under the SA private panel at this point. So you can see there that when you're an independent children's lawyer, you could be employed by legal aid or employed privately. The the critical question is then, so when is an independent children's lawyer appointed? So you'd think it would be quite obvious, perhaps not so obvious, that an ICL would be appointed in parenting proceedings. I say that it might not be obvious because those legal eagles who have joined us, take a look at section 79, which you'd know is in relation to property matters. And that section of the Act actually enables an ICL to be appointed, because sometimes when you're looking at property orders, section 79 is looking at, well, what's the best interest of a child when making property orders? So technically we could have an ICL appointed in property matters. I can tell you in the 17 years, I've not seen it happen. Be super keen to hear from any of you legal eagles as to whether you've seen it and what your thoughts are about that. It's quite interesting anyway. So we're also, when the ICL is appointed, is if it appears to the court that the child's interest in the proceedings ought to be represented. Now, what on earth does that mean? Okay, because that's pretty vague. How is the court meant to know when the child's interest should be represented? And that takes us to some case law. Again, I'm not going to go into the nitty-gritty of the case law because I know that we've got a variety of people tuning into this webinar. But if you are particularly interested, I've got the reference there. So this is a full family law court case and it's called Re-K, and it sets out specifically the guidelines and circumstances as to when the full court thinks that it would be appropriate for an ICL to be appointed. So I'm just going to go away from the slide there and talk on the facts of that case to tell you the story of what that case is, because that's going to be of more interest and perhaps relevance to you. So this is a family that separated in March 1992. In April 1992, the mother obtained an intervention order, a protection order against the father. And in September of that year, there's a 3-year-old boy, is the only child of the relationship. September of that year, the father shot and murdered the mother in bed while she was next to the little boy. Tragic and, really, really tragic situation. Father was subsequently charged with criminal proceedings, with murder. We've then got proceedings in the family court brought by the maternal auntie. The mother's sisters travelled from America back to Australia because her sister's just been murdered. And she applies to the court to have what they then called custody of little 3-year-old boy. We've then got the paternal family, so dad's mum, paternal grandma, and paternal aunt, also in the proceedings, wanting custody of the little boy and for the little boy to stay in Australia. So it's a really very, very sad, tragic set of circumstances, but also incredibly, from a legal perspective, very interesting. Ultimately, what the trial judge did is he made an order for the little boy to be living with the maternal auntie and to be able to leave Australia to live with the maternal auntie in America, and sole custody and so on. Okay. The father appealed, which is not unsurprising, and this is where we then come up with these guidelines around, well, when is a children's lawyer to be appointed? And I'll just pause at that point and say the reason it's really relevant is an ICL was not appointed in that matter, and I find that particularly interesting. And I can't imagine these days, so this is back in 1994, I can't imagine in the year 2000 an ICL not being appointed in circumstances where there's been a murder and, on top of that, international relocation elements. But anyway, here we are. So excuse me while I have a sip. So what we had in that case in the appeal, full court, family court, Attorney General intervened. So think of like Department of Child Welfare intervened because they said, look, we've got an interest in this as well. I could swear and say no, S-H-I-T, but anyway, that was a little bit too late. But one of the things they said during the appeal process is that their view was that a child rep should have been appointed initially. So that's where this all comes from. And the full court said, yes, in those circumstances, it would be appropriate for the ICL, for a children's lawyer to be appointed. And this is where we come up with the guidelines. So I'm just going to move to my next slide. So in doing so, the court considered what our obligations as a country are under the United Nations Conventions on the Right of the Child, which is such a critical convention, and we adopted that in Australia. We ratified that in, I think, the end of 1990, a long time ago. But Article 12 says, look, if a child is capable of forming their view, then that view ought to be considered. So that was one of the main things that they considered as well when they came up with these guidelines. So there's 13 guidelines. I'm just going to bring them up now. And you might think some of them seem a bit, self-explanatory, a little bit obvious. But remember, this was back in 1994. And at this point, we had a matter where there was an international relocation and a murder with the little boy next to the mother that was murdered. And even in those circumstances, there was no appointment of the child rep. So these guidelines, firstly, where there's been an allegation of child abuse, so that's whether it's physical, sexual or psychological, an apparent intractable conflict between the parties. The emphasis there is on the word intractable, because I would argue, and I suspect my lawyer friends who've tuned in would argue that, look, any matter that's in court can potentially be described as already having a high level of conflict, okay? Alienation, so if there's allegations that one or both parents are being alienated, cultural and religious issues. Number 5, sexual preferences. So again, remember this is back in 1994. And at that point, even at that point, which is quite interesting, the court said, look, it's not an issue around, for example, if there's a same-sex relationship. That in itself is not concerning, and that in itself won't form part of the guidelines for an ICL to be appointed. But only to the extent that that affects their parenting ability. So this was way before same-sex marriage. So perhaps the court was a little bit ahead of its time at that point in not having an issue or concern about same-sex, rightly so, by the way, relationships, in my view. So that's the first 6. Oh, sorry, the conduct of parties being antisocial, including family violence. This is so common, and most of the matters where I'm appointed as ICL are matters where the conduct of at least one of the parties can easily be described as antisocial. And so many matters that we're seeing come through the family law courts do involve allegations of family violence as well. So then we move on to 7 to 13. So just to recap, these are the guidelines set out in case law around when the circumstances when an ICL should be appointed. So number 7, if there's medical illnesses, psychiatric or psychological illnesses or personality disorders, that's not only in relation to the child, but also in relation to the parties. Okay, so it's not uncommon for me, for example, to be appointed as an ICL if one party is really struggling with mental health issues. If neither party or parent is suitable, if a child's a bit older and of a mature age needing to express their views, or if there's a strong wish to express their views. Number 10, removal of a child from Australia, particularly to a non-Hague Convention country. A non-Hague Convention country is one where there's little in terms of remedy to have a child returned to Australia. But we're also talking relocation, and relocation matters, particularly where one party is unilaterally relocating the child or has made an application to do so. And I did have a matter actually where I was independent children's lawyer throughout the substantive proceedings, and the father was from Egypt, and he reapplied to the court to be able to take the little boy, again, a little boy, to Egypt for a holiday. So I was reappointed as ICL in that matter, even after the substantive proceedings had been finished. And I had some really serious concerns at that time around the father's conduct and the risk that the child would not be returned to Australia. So I sort of had to make that assessment, which to a large extent was based on my experience throughout the substantive proceedings and my knowledge of the family and the father's previous conduct and disregard for orders. So I did not support that child being able to go on the holiday to Egypt. And ultimately the court agreed with my submissions. I had no confidence at all that the little boy would come back. And I've seen that happen all too often, particularly when I worked in Sydney. There was so many matters in Sydney where one party would unilaterally take a child to a non-Hague Convention country, and very difficult to get those children back. So the other guidelines, if an ICL will be appointed if there's potential separation of siblings, in matters where there's self-represented litigants. This is a big one because, and I must say that a lot of my ICL work at the moment is when one or both parties are self-represented litigants, and sometimes it can be some of the hardest work because when you're going through family law matters without the support of a lawyer, you don't have that guidance and legal knowledge and support, and sometimes you can be a little bit off in terms of what you think should happen and what the law says, because that does not always marry up, and I'd fully appreciate that. So I find personally as an ICL, they're some of the most difficult matters to have conduct of and to assist the parties with, because there's a lot of perceived unfairness of the system and so on. A lot more people are self-rep these days, particularly jurisdictions like here in Perth and in Sydney where legal fees are a bit higher. It's kind of precluding people from being able to afford legal representation. Legal aid can get a bit tougher in different states. So we are seeing that flow through of more self-rep litigants. So I suspect that's why there's more ICL appointments in those circumstances. And I can tell you, with respect to my judicial officers, there are some who will be very quick to appoint an ICL in circumstances where both parties are self-rep, because when we come on board, that's seen as a big assistance to the court to try and work things out, okay? And finally, the other guideline set out in this case law is medical treatment. So I'd had a matter which was tragic. It was about 5 years ago, and we had I was representing a early teenage boy, and he was dying. He was about to be bedridden, and he had years, but more likely months left to live. His death was imminent, and it was very tragic in that the parents could not agree how to care for their boy, their son. They both dearly loved him. There's no doubt in my mind and the court's mind about that. But what couldn't be agreed is his living arrangements, how he was going to, travel from a mobility perspective. He was about to be bedridden, from house to house, how much time he'd spend in one house and the other, and also his particular medical treatment. So that's an example of where an ICL might be appointed. So that's 1 to 13 as set out in that case. They're guidelines only, and it's not exhaustive. So the court made it really clear, look, here's our guidelines, because we've never had guidelines. These are matters where the court needs to give serious consideration to appointing a children's lawyer. However, it's not exclusive. There will be other examples of where it might be appropriate. So who can apply to have an ICL appointed? Believe it or not, a child themselves can. Again, in 17 years, I've never seen that. Again, if anyone here has experienced that, I'd love to hear from you. I'd be really interested to have a chat about that. The legislation says that can happen, but practically it does not happen. Any organisation concerned for the welfare of a child can apply. So that might be like Department of Child Protection, for example. And then the legislation says any other person. So, it's quite broad. It's any other person. And in terms of how you actually apply, there's a couple of ways. So we see applications made to the court. So when you're filing your application, you might seek that order because you or your lawyer recognises that this is a matter where it would be appropriate for an ICL to be appointed. An application might come at a later date throughout the proceedings where the situation's changed. So, for example, and I'm just thinking of this at the top of my head, for example, you've got parenting proceedings going along quite nicely, or as nicely as they can, and we then have mum re-partners with a man, and there's family violence and drug use, and mum in those circumstances is no longer perhaps suitable, or there's real concerns about what's going on in her household, and those concerns were not there at the outset of the proceedings. So it might be there's an application then by the father for the children's lawyer to be appointed. So it can happen at any stage. Sometimes things change quickly in people's lives and in court proceedings. So it's not always necessarily a paper application. So sometimes it might just be oral submissions. So, it'll be, you're on we've just learnt that such and such has happened, or, someone's been imprisoned, or someone's been charged with XYZ, and Your Honour, we make those verbal submissions for the appointment of the independent children's lawyer. The other way is sometimes the judicial officer will make that order him or herself without any application before the court. Sometimes they'll do it because they think there really should be. Other times it will be to help them through the process, which is fine. That's one of our roles. And again, as I said before, sometimes it's when both parties are self-represented. Sorry, just moving on to my next slide. I'm just going to make that a bit bigger for you. Just bear with me. There we go. So what exactly is the role of the ICL? So I've set out the sections of the Act. Non-lawyers can ignore that, but read the words, obviously, ignore the section of the legislation. What the law says is that our role is to form an independent view based on the evidence that's available to us about what is the best interest of the child. So I'll just repeat that, and it's around what is the best interest of the child. We must act in a way that's in the best interest of the child, and we must make submissions for the court around what we think is the best interest of the child. I'll pause there again to say, despite what we might recommend and despite the submissions that we make to the court around what we think is the best interest of the child, doesn't mean the court's bound by that. And it's not common, but also not uncommon for the judicial officer to say, look, with respect, thank you for your view, but I disagree with that. So they're not bound by it, just like a judicial officer is not bound by the recommendations, for example, of a family report. So it's one thing that helps the court to make a judicial determination, but yeah, there's what we say is not gold, even though some of ICLs might think it is. Okay, so what we're not the child's legal representative. So I mentioned before the change in the terminology back in 2006. We're not obliged, we're not required to act on the child's instructions. We're not direct representatives. And I've put here a comparison because I find this quite interesting, and I did a bit of care and protection work when I was working in New South Wales. And there I was acting for children. So there is this myth, and I see this myth a lot on social media around, 12 years old. When a kid's 12, they can give direct instructions. And when a kid's 12, they can, their wishes are taken into account. When a kid's 12, they can choose X, Y, Z. It is a myth, but in care and protection work, in almost every single state of Australia, when you're in care and protection work and you're appointed for a child, if that kid's got capacity to give instructions, then we are appointed as a direct representative role. And likewise, in criminal proceedings over most states, again, when you're appointed in youth courts or children's court to act for kids in criminal proceedings, you're directly represented. And usually children know the events that have led up to them being in this position of a criminal charge. So it's interesting because in family law matters, it's quite unique in that the whole point of these parenting proceedings is about this child. The proceedings are about them, but they're not a party to the proceedings. So we've got care and protection matters where we're direct reps, criminal matters direct reps, but we're not in family law matters. They're the subject and the focus of the proceedings, but they're not party to the proceedings. And I've just put at the bottom of the slide there, one thing that we can do, and I'll advise children of this when I speak with them, is that we can actually disclose information that children tell us, even if it's against their wishes. So again, that's quite different from a direct rep point of view, because if we've got a client and they're giving us different instructions and they don't want us to relay certain things, then we generally don't and can't, depends. But with children, we have an obligation to disclose certain information that we think is in their best interest and or of concern. So that's you can see there the role is very, very different. One thing we can't do is we can't require a child to express their views. We have the power under the Act to ensure that they're available to speak to, say, a family report writer and so on, but we can't make them give us their views. That's not what we can do. Okay. So that said, how does the children's lawyer let the court know what the child's views are? So this is a very common question. This is very much something that comes up a lot in social media, on the forums. I personally have received a lot of abusive language and so on from random people I don't know who really dislike independent children's lawyers. That's the nature of social media, I suspect, and I don't take that personally. But what I can see is that there's a real, sometimes a dislike by certain people around independent children's lawyers, and there's a real confusion around how are you going to know what the kids want if you don't meet with them, how are you going to get those views to the court, etc., etc. So this slide, how do we, how do we let the court know what the child's views are? And we need to remember the importance of the child's views. We need to remember that the Family Law Act says we have to consider their views if appropriate. It's one of the things that we need to consider. We need to remember that kids don't go to court. You won't see children in the family law court. Kids in Australia don't speak to judges. Kids don't file documents. So in those circumstances, how the heck do we know what they want, if relevant? So there's a couple of ways I've popped there on the slide. We've got child-inclusive conferences, which is where a child or children meet with the family consultant at the court usually and have a bit of a discussion around that. The consultant has access to all the family court material, documents and so on. That's sort of short form. We then have the more detailed family assessment report, which is often ordered in matters where there's just not going to be a resolution, in matters that are ultimately going to be listed for trial. So we'll have an independent family consultant or expert preparing a family report. And part of that assessment process is that they actually the children meet with these professionals. They're, social science professionals. And we then have a report with recommendations and so on. And I find that is going to be much more useful and more appropriate than, for example, if an ICL were to meet with a child and say, what do you want? Because I'm not trained to do that. I'm not a social scientist. See, I can't even say it, so I'm definitely not. Okay. So that's how we can obtain children's views. What weight do their views hold? Excuse me, guys. So there is the clear principle that the court has to consider the children's views, and that's set out really clearly in the Family Law Act. What we also know is that the court's not bound by those views, so it's only one consideration. And one of the things the court will take into consideration is the child's age and maturity when they express those views. So, for example, I act for children of all different ages. If I've got a 5-year-old who's talking to a professional, a family consultant who has views around, I want to live with mum, it's very different to a, say, 13-year-old who says stuff this, there's no way I'm going to live with mum anymore. I'm just not going to do it. And if you make me do it, I'm going to run away. You can see how that's very different. So we need to look at the age and maturity. That said, I have had teenage children that I've represented who've not been as mature, if I can put it that way. They might have had, and I'm not joking about this, but they might have had intellectual disabilities, for example, or their views are so clearly not in their best interest. So, I recall one girl, I think she was 13, really wanted to live with mum. Mum's household was just diabolic and really not safe. And there was no way that the court was going to make that order, even though we had an older child expressing those views. Okay. And that actually leads me to my next slide. So the wishes of the child is only one factor. And ultimately, what's going to override all of that is what is in the child's best interest. I've just popped the case law there for any legal eagles who want to look at it. It's a High Court case in that matter. It's quite new, actually. You've probably already heard of it, but for those who don't know, that was a High Court matter where there had been ongoing family court proceedings, and in the midst of those proceedings, the father, not unilaterally, he took two of the children, 15 and 17-year-olds, to New York, and the mother agreed on the basis that it was a holiday. But once they flew business class, by the way, and first class, lots of money. And once they got there, the children decided they didn't want to go home to Australia. So we've got current proceedings. Dad's taken off to New York and has no financial incentive to come back. He's cashed up, and we've now got two older teenage boys, 15 and 17. So you'd think in those circumstances, these older children, their views would hold more weight. Ultimately, what the High Court found is that the children's views is absolutely relevant, but it's only one factor that needs to be considered. And the court was highly, highly critical of the father and his conduct, and overall found that the children should be returned on the basis of their overall best interest and the overall things that the court needed to take into consideration. So that's an excellent case that shows that despite having a 15-year-old and a 17-year-old even giving these views, the children were still ordered to be returned to Australia. So sing out anyone if you want me to send you through that case. So in terms of the specific duties of the independent children's lawyer's role, we have to act impartially. And you'd think that would go without saying, but unfortunately it does need to be said. And I'm very mindful myself about, at the very least, appearing to be keeping my distance from other practitioners in the matter. So it's very common for all family law practitioners to know each other and be friendly. When we are acting as independent children's lawyer, it's very unfair on parties to be perceived as having some sort of alliance with, having some sort of alliance with one of the parties' counsel, one of the barristers or solicitors. And that's not to say in those circumstances of us having a chat or going for coffee after that we're not impartial, but it's definitely definitely something to be mindful of for those that do practice as children's lawyers, because there's nothing worse as a parent or someone who's a party to the proceedings and you see the ICL off talking to someone else, the other party's lawyer. It's just really, it's not to say that ICL's not being impartial, but it's really not a good look. Our specific duties are also to ensure that the children's views are put to the court, even if we disagree with them. So I've had some funny ones over the years, which, sometimes it's a little bit embarrassing to say certain things in court, but you'll say, this is what I've been asked to put to you. Then I disagree with that. But yeah, that we have to ensure that those views are put to the court. We have a role to analyse documents, reports, and subpoena material. So I spend a lot of time reading through medical records, and I spend a lot of time reading through Department of Care Protection notes, case notes, and a lot of time reading through criminal case notes as well. It can be quite tedious at times, but absolutely critical. And some of the information that we come up with, and particularly when you're doing a chronology and you're marrying up different incidents from different dates, that's coming from an independent source. So it's not coming from the parties, it's not coming from mum and dad, it's coming from the police, for example, can really help to get you to form your views and paint a better picture around what's actually happening in this family and what's actually happening for these children. So our duties continued. So we have to ensure all relevant matters are drawn to the court's attention. We can obtain information. So often I'll speak to school teachers, school counsellors. We can speak to medical professionals. I don't always understand what they're talking. I suspect it's a bit two-way there. There's a bit of a miscommunication. We have an obligation as a children's lawyer to minimise the trauma to the child. That's a really difficult one because sometimes that's just impossible. Sometimes minimising trauma to the child will be by way of what's leading on to the next point, is to try and facilitate a resolution of the matter. So in other words, the quicker the proceedings are finalised and the quicker we can hopefully reach consent orders by agreement, that in itself will minimise the trauma to the child. But aside from that, it's actually the very difficult part of our role. Excuse me. So what I've found and what's really clear to me is that there's a real lack of unified approach by independent children's lawyers across the country. Every state differs. So as I mentioned, each state has its own legal aid system. As a result of this, we had some national legal aid ICL guidelines, first of all put out in 2007. And again, the most recent is 2013. This week I had them both up side by side, mirrored, comparing the two. I couldn't find one. There was a couple of differences just in words, but the principles are exactly the same. So I can confidently say that the same guidelines have actually been in place since 2007. And they mirror the current guidelines, and they're endorsed by the Chief Justice of the Family Court and of the Federal Circuit Court, and so they're endorsed by the judges. And what these national guidelines try and do is basically address the fact that there's such a discrepancy state by state as to what all these different ICLs are doing. And I think I've had the benefit and perhaps confusion because I've worked as ICL in different states. It is so different. So just let me pull up my next slide there. And I'll just make that a bit bigger. There we go. So the 2013 guidelines, again, pretty much since 2007, what they say is that the ICL should ensure the child is always involved in the decision making, and the child has a right to establish a relationship with the independent children's lawyer. And I can tell you, working in Sydney and New South Wales as an ICL, Very common for the ICLs there to give children their direct telephone number, which I have not seen in other states. There's the guidelines say, and these are national guidelines, legal aid guidelines, that we need to liaise with professionals, which I've just said. We need to explain our role to children, and we're not to become a witness or conduct therapy. That's the last thing that I would ever want to do. I'm not trained to do that, and it would not be appropriate for me to do that. Now we're back to the meeting with the child, and we're back to this topic that just seems so many people, parents particularly, disgruntled with our system. Why doesn't the ICL meet with our child? So what the national guidelines say is this. It says that we should meet with children unless, so the exceptions are if they're under school age, if there's exceptional circumstances, such as and exceptional circumstances might be, for example, there's current welfare investigations, and that's quite frequent, to be honest. It might be if there's risk of systems abuse. So if we've got children they've met with this social worker, they've met with this copper, they've met with, there's been a forensic report here, and now they want to meet with a children's lawyer. You just don't want, it's not good for children to be exposed to systems abuse. And the final one is geographical restrictions. And I suspect most of you as taxpayers would not take issue with that. So for example, working in Adelaide, when I worked in Adelaide as an ICL, and those not from Adelaide, there's a town called Ceduna, there's an Aboriginal community out there. I would fly to Ceduna and stay up there for a couple of days and then fly back to Adelaide. I was employed by legal aid at that time. If I was to do that as a private practitioner, the cost would be enormous to the taxpayer. Or if I'd accepted it on a rate that was offered by legal aid, I just, as a small business owner, couldn't afford to do that. I'd be losing money, a lot of it. So it's just those geographical restrictions, they're real, okay? So in terms of practical points, how the ICL is appointed, I've already said the orders made by the judge, but then what happens next? So actually, I just want to move back because I'm just going to move back because there's something there I really wanted to say in terms of the difference about state by state. When I worked in Sydney as an ICL for legal aid there, what we had there was we had a room set up to meet with children, like a child-friendly room that was there for the sole purpose of meeting with children. There was regular face-to-face meetings with children, and as I said just previously, expectation or usual course was the kid would have our direct telephone. Adelaide, not so much. There's no specific place set up, and there was AIFS studies on the independent children's lawyer, which was done in June of 2014, a big study that AIFS did, and they spoke to judicial officers, ICLs, parents, all sorts of people who were subject to family law proceedings and wanted their views around how ICLs work and what in practical terms was happening state to state. Again, if you want a copy of that report, that's quite interesting, that one. But one of the things that was found in that report was state by state, there's a huge discrepancy around whether ICLs meet with children or not. And there was some level of resistance shown, particularly in SA and Queensland practitioners, in terms of not meeting with children. And I also know from having appeared a lot in court in Sydney and Parramatta, Sydney Parramatta registries are quite different in themselves, by the way. That's another webinar. But if you were appointed as ICL and you got to the first court date after your appointment and you'd not met the child yet, you would be questioned about that and the reasons for not having done that. Whereas my experience in other states is that the judicial officers are not questioning that and they're not asking those questions or raising those concerns. So just going back to my slide around the practical points about how the ICL is appointed. like I said, the order's made by the judge, and then what happens is the request is put through to legal aid for that particular state. Another way it can happen, and I saw this again in Sydney, very rare, but there was a matter which was, hot topic in our legal aid office at that time, because private parties, so private paying parties, paying big boy law firms, had decided that an independent children's lawyer was needed in their particular matter. They funded it privately and they arranged this third-party lawyer themselves. So it didn't go through legal aid at all. They just said, look, we want solicitor X, we're both going to pay towards their fees. That's very rare. Normally what happens is it will go through the legal aid body of the particular state. What we're met with again is differences from a practical perspective, state by state. So I mentioned before, you've got in-house legal aid lawyers or private lawyers like myself. So when I'm appointed, I'm paid for by legal aid at legal aid rates. And who pays for it? Generally, it will be funded by the legal aid body of the particular state, but each state there are discrepancies. So for example, in Victoria, there was at one point, I'm not sure if they're doing it at the moment, but at one point in Victoria, once the number of requests for an ICL met a certain number per month, that was it. It was capped, and any further request from the court after that would be rolled over to the next month. So real restrictions there in terms of funding. And remember those guidelines of that case law before, from 1994, 1 to 13, the guidelines. There's other states such as Western Australia and I've forgotten which other state. Sorry, I just forgot that offhand. Definitely Western Australia. I think it might be Victoria as well, but they will only appoint an ICL when the court requests it if one or two of the 1 to 13 are met. So in other words, there might be, say, separation of sibling criteria met, but legal aid will say, no, sorry, that doesn't meet criteria 1, 2, or 3. So even though we've got this established case law, we've got national guidelines, we've got, the court endorses that the case, and the court has made the order requested for the ICL to be appointed, we've still got some legal aid bodies saying, well, that's fine, but we politely decline to do that. So the cost of the ICL will be met by legal aid if the parties are in receipt of legal aid. If one or both parties are not in receipt of legal aid, then the cost that they contribute, the amount they contribute towards the cost of the ICL, can be waived, and they need to complete an application to waive those fees on the grounds of financial hardship. Just keep in mind as well that some people who are in receipt of legal aid will also be, they might have, first of all, there's caps to funding, their funding. If you're in receipt of legal aid and you own a property, your legal aid funding is going to be claimed back at a later date from legal aid by way of stat charge that's registered on the title. So if you've got your own lawyer's fees and then you're adding the independent children's lawyer's fees on top of that, that's an extra financial burden, even in receipt of legal aid, that you're not going to feel immediately. But whenever you go to sell or transfer your house at a later date, you will have to pay that back. Very important to keep that in mind for anyone helping legal aid clients who do own their property and are subject to the stat charge. And it's really important to give that advice to parties as well. So, next slide. The end of the ICL roll. Okay, so I'm nearly towards the end actually. I've done quite well for time. When does the role of the independent children's lawyer finish? Well, normally what happens is it will finish at the time that the final orders are made. So one of the orders that will be made is that the appointment of the independent children's lawyer be discharged. That's a fairly standard order. Sometimes, it's quite rare, but sometimes will be asked to stay on as an independent children's lawyer so as to ensure that certain things are done. So, for example, might be for another month for us to monitor something, or for us to liaise with someone or provide a report to someone, for example, usually quite a defined period. It might be for us to satisfy ourselves that the parties have done X, Y, Z, for example. And if it hasn't, then we might have liberty to bring the matter back to court. Discharging an independent children's lawyer, we have a lot of clients who are that we act for who are unhappy with their ICL. They think the ICL is biased or useless, and worse words than that. And they say, can't we get rid of them? Can't we file an application or discharge them? And I have a lovely friend of mine who's an old barrister. He's been around the traps for years and years, excellent ICL, and he once had a self-rep party request the court that he be discharged on the basis that he looks like a homeless person. So we see all sorts of stuff, but the reality is that to have an independent children's lawyer discharged on those grounds of, put aside the homeless rubbish, okay, but on the grounds of bias and so on, it's so hard to prove, and it rarely happens. If you're currently going through court and you've got concerns about your ICL, then have that conversation with your lawyer if you've got one. If you don't have one, speak perhaps to, say, the duty lawyer or someone that can talk you through that. There is, and I'm not going to talk through this case, but I'm mindful of the time, but I've put Stacey and Woden there. For any of you law students or lawyers listening, check that out. It's really fascinating in that the court, a 7 and 9-year-old, and the court made an ongoing order at the ICL's request, mind you, that the ICL remain appointed until both children turn the age of 18. The ICL was really unsatisfied with welfare, Department of Child Protection. The ICL had no confidence that they were going to keep an eye out for these children. So the ICL sought orders that they continue to monitor the situation, speak with the school and so on. Quite an unusual case, but it's very rare for that to happen. So normally what happens is the ICL will be discharged at the time of final orders or soon after, often soon after, to enable us to explain orders to children also. So I'm just going to finish on this one. This is something I've written. The role of the ICL is a privilege and should be undertaken with respect to the court, to the families involved, and to the child. I feel quite strongly about that. I've seen too many examples in the past of people sort of rubber stamping and not doing due diligence in their role as ICL, and it's just not satisfactory. We really need to be mindful of the importance of this role, and it really is one that is privileged. There's my details. Again, like I said before, I've covered a bit of case law and legislation, so I hope I've not bored non-legal people with that. I hope it has been relevant to give some context around why things are done a certain way. If anyone wants copies of those reports and so on, please do let me know, because I'll certainly be happy to either have a chat to you about it or provide it to you. Now, I just want to check, and thank you for your time, by the way. There's no open questions at the moment. I'm just going to check through the chat box to see if I've missed anything. Kerry, you want a copy of? Yep, no worries, Kerry. Anne-Marie, it's been great. Thank you. Oh, thank you, Anne-Marie. Nice to hear from you too. Yep, slides will be available. Yep, so everyone that's joined us, thank you so much again. I really want to, I suspect I've covered your questions, because there's no questions down near the polls. There's a question box. If you've got any questions that you feel I haven't covered, you've got about 20 seconds to type quickly. Okay, Keisha, what are your views and how can you tell a child has been coached? Oh my goodness, you know what? That's a really good question, and that's a question, Keisha, that we get asked so often when we act for parents. And you know, the other thing is that when children are going into a situation of, for example, meeting with a report writer, the concern our clients often have is, oh, but they're going from mum's house or dad's house and they're going to be talking in their ear and they're going to be coaching them, or they've been exposed to ongoing coaching around what to say. So that's a really common concern. And what I would say to that is that as an ICL, this goes back to social sciences, I'm not qualified myself to be able to tell if a child's being coached or if a child's telling the truth, for example. But that's why we really rely on expert psychologists to meet with the children. And what I say to clients who have this concern is these professional family consultants and psychologists who regularly meet with children, they see everything. They've seen it all before, and they're trained to be able to deal with these situations as best as possible, and hopefully be able to tell if there's issues of alienation or coaching and so on. So I hope that answers your question. I can't tell myself. May have suspicions, or I may liaise with experts who feel that way. But as a children's lawyer, we are that. We're lawyers. We're not trained otherwise. Thanks so much. I'm a law student, and this has been thanks, Keisha. I'm glad that answered your question. Any other questions, guys? I'm happy to stay on. Type quickly. Most of you are still online, so that's good. I've lost one person, and that's it. So I'm happy about that. And I've now just gone over the hour mark. Esther, thank you, Esther. Thank you, Lauren. Alrighty, there's no more questions. So look, thanks guys. If you've got any questions, call me or email me. My email is there on the slide. And if anyone wants to book an appointment with one of our lawyers to talk about your own matter, you can book online on our website. You can book instantly a phone call or a face-to-face chat, whichever you prefer, and that's complimentary. Thanks for your time. I hope it's been interesting, and yeah, I really appreciate it, guys. It's been good fun. Okay, see you. Bye.